Welcome everyone to the 2024 Benefits Compliance Highlights and Recap. Thank you all so much for joining us. The team will be answering the questions you send through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we're unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At this time, I'll hand it over to Kelly Ackman, Vice President of Benefits Compliance at NFP. Kelly, the floor is yours.
All right, thanks, Amber, and thank you everyone for joining us today. I know it's still a busy time for many of you. So we're doing our 2024 recap and then looking ahead at what benefits compliance may look like for 2025. If you've attended in some of our past years, you may remember that in December we do it a little differently. So instead of just having 2 or 3 presenters, you get nearly our entire benefits compliance team. So we'll each be tackling a different topic today. Throughout the presentation, you'll hear us mention various NFP publications that will correspond to the topics we're covering. If you'd like a copy of that publication, please reach out to your consultant or someone on your NFP account team to make sure you get a copy of those. And as Amber said, the webinar is being recorded. You will get a copy of that and the slides. And then if you have questions that come up during this, please submit those by using the Q&A function and not the chat function, please. Okay, and as we always say, our reminder that, what we're covering today is just general guidance purposes. It's not legal advice. It's not tax advice. Clients, you need to work with your own legal counsel if you do have a question about that. As I mentioned, we have most of our team here. 2 of our newest members, so David Rotman, we don't have his headshot yet, but he'll be joining us, and then Molly Sled. They are the 2 newest members of our team, so welcome and thank them for joining us today. We've got a pretty busy agenda, so we'll move through it. So we're going to be looking at mental health parity and what came down in 2024 and what to expect in 2025. We've got some late-breaking news on ACA reporting changes. We're going to look at court cases that may be impactful for employers. We are looking at transparency and ERISA fiduciary obligations for employers, state law trends, which is always something a lot of you are interested in. And then we're going to look at the political landscape. We just had an election. So how is that going to impact benefits in the coming years? And then we'll round out with our year-end reminders. So we'll go ahead and Sarah will get us started with mental health parity.
Thanks, Kelly. Yeah, so we got some new long-awaited final rules on September 9th. They are extensive. They were 536 pages to be exact. And we could spend all day talking about MAPIA, but we've got loads of other topics, as Kelly just mentioned, to cover in the hour. So we're going to go through fairly quickly and point to some of our other resources for more information. But let's start with a quick recap on MAPIA before we touch on the new rules. As I'm sure you all know, the law has been around for years, since 2008, but certain aspects of compliance have been really difficult to achieve, particularly those related to non-quantitative treatment limitations, right? Things like coverage exclusions, prior authorizations, medical necessity guidelines, any coverage limitations that can't be quantified and easily compared, like cost sharing or visit limits can be. So back in late 2020, the Consolidated Appropriations Act of 2021, CAA 2021 there, introduced a new NQTL comparative analysis requirement. So that's where plans and insurers must actually document NQTL compliance, and it's been in effect since February 2021. So that requirement's not new. That's been in effect for a few years now. But basically, the comparative analysis is about identifying each mental health NQTL and then justifying its inclusion in the plan. To justify by showing that it's somehow comparable to medical surgical coverage terms. And it needs to be done through a detailed and reasoned analysis. So there's no requirement to routinely submit a comparative analysis, but it has to be on hand to be able to quickly reply to a request from a federal or state agency or a plan participant. And for the past several years, MAPIA enforcement has been clearly identified by the DOL as an enforcement priority. So a few highlights in the final rules. The overall theme is ensuring equitable access. The departments believe that these NQTLs are barriers to accessing mental health treatment, barriers that aren't applied on the medical side. So what do I mean by access? I mean like problems finding an in-network therapist due to lower reimbursement rates or licensing requirements. Like if you go to the pharmacy and you can't get your prescription filled because the plan requires prior authorization every 3 months. Well, that prior authorization is an NQTL, so what's the justification for it? Or a plan exclusion for wilderness programs for teens. This is a common exclusion. That's an NQTL. What's the justification for it? And in large part, the final rules map out a complicated route to justify these mental health NQTLs. That's really where those 536 pages come from. But at a high level, which we think our clients just need to know, the high level of it, not the details of the testing. The rules require that the NQTLs are designed based on generally recognized standards of current medical practice. So they can't be based on biased standards. And this has always been the heart of the law. The departments and Congress really are concerned with discrimination. I think of certain wilderness program exclusions, right? I mentioned that before, that they're based on some outdated notions that these programs are like a camp or they're dangerous, rather than just residential treatment programs that happen to take place in the wilderness, which is what they mostly are now. The point is they've changed over the years and that the coverage guidelines in these plans, in all of our plans, need to keep up under MAPIA. So the final rules also add a meaningful benefits requirement, and that means that the plan needs to provide a full range of treatments for mental health conditions. The rules call these core treatments. As an example, it would be a problem to exclude applied behavioral analysis therapy for autism or nutritional counseling for eating disorders, because those are primary treatments for those conditions. Kelly, can you go to the next slide? So on to the fiduciary certification. This is another important highlight in the final rules. There's a new requirement for a named ERISA plan fiduciary. And typically this is going to include an insured and a fully insured plan and sponsoring employers for both fully insured and self-insured plans. The fiduciary certification requires that the plan fiduciary, just one, certify that they have engaged in a prudent process, that's the key term, to select and monitor what the departments refer to as a qualified plan service provider, so like a TPA, to complete the comparative analysis. It's not that the fiduciary needs to certify compliance with the content requirements, and this is a key change from the proposed regulations, but just that they went through a prudent process to get it done. But self-insured employers especially, they need to take an active role in the comparative analysis process. They need to review findings and make plan changes as needed. They also need to get assurances from the service provider that the analysis complies with MAPIA. And this really all aligns with ERISA fiduciary duties generally, so it's not really a change in the law. As far as the actual certification goes, the departments haven't provided a model, so they're not being particular about format, at least not yet. Next slide, please. So onto the basic question, which I'm sure is on all your minds, it's on all of our minds, which is how to comply. So there's a distinction and responsibility for the comparative analysis based on whether the plan is fully insured or self-insured. For a fully insured plan, the insurer and plan sponsor, the employer, share responsibility. But then for a self-insured plan, the plan sponsor is going to be fully responsible under MAPIA. So for a fully insured employer, they need to confirm that the carrier has completed the comparative analysis and have that on hand. For a self-insured employer, it's more complicated. They must work with TPAs to complete the comparative analysis. They must work with TPAs because TPAs have all the information on the plan coverage terms and guidelines, how they were designed, how they are applied. But TPAs aren't directly responsible under the law for the analysis. So this puts self-insured employers in a really difficult place. Requesting the TPA's comparative analysis is a good place to start. And typically TPAs are going to provide a standard model, which is often the same plan design as a self-insured plan. But then there's a need to address any deviations from that standard model. Beyond that, self-insured plans need to engage with the comparative analysis, review with legal counsel, whether it's detailed, whether it's reasoned, whether it's complete. and then also compare that to their plan document. Are there any what we call red flag and QTLs? We have a list to help with that. And those were all pulled from DOL guidance that we've gotten and also some lawsuits. But red flags are things like prior authorization requirements that seem to be heavier on the mental health side than the medical side, more frequent continuing care coverage reviews or exclusions of key treatments for mental health benefits. So if there are red flags, like if there is an exclusion, that's where the employer needs to really press the TPA for that detailed and reasoned comparative analysis. And if it's just not there, then remove that NQTL. And we always say that employers need to pay attention to participant complaints because these signal trouble, right? The DOL is not spinning a giant wheel and picking plans at random to investigate. Those investigations are often triggered by participant complaints, and then also there's other risks from lawsuits, right? From these participant complaints, the ERISA lawsuits are going to start with a claim denial, which is essentially a complaint. And then lastly, it's important to confirm with the TPA that the agreement addresses MAPIA compliance, right? That they will provide a comparative analysis and that they will help respond to any agency request or a participant request. So as a self-insured plan, if you find yourself in a position where the TPA is not going to provide even a model comparative analysis of their plan design, you'll need to work with legal counsel or a vendor to provide one. And the departments have said that with these new rules, they didn't intend to create a new service provider. And by that, I mean a new testing vendor, comparative analysis testing vendor. Really, their expectation is that the TPA is going to complete the analysis. But the problem is that the law doesn't impose a direct legal requirement on TPAs. That needs to be addressed through agreements. So, but if a plan ends up, needing to work with another testing vendor to complete the analysis, they still need to go through that prudent process. That's really what is key. The prudent process to vet the vendor's expertise and get assurances that the analysis is going to satisfy the requirements. Next slide, Kelly. So we're expecting additional guidance from the departments to these rules. It's also possible that these new rules are going to be challenged in court and then perhaps not defended by the new administration or pulled back in some form. And Sharon's going to provide a bit more context on that when we get to the political landscape section. But trust that we're tracking it closely and we're certainly going to report on any new guidance and compliance corner. In the meantime, we have that publication right there that lists some of those red flags I was referring to. Please ask your broker or consultant for a copy. There's also a link to our September 10th Compliance Corner article summarizing the final rules. Yes, that's September 10th, the day after the rules were released. We also have a link to our August Get Wise Wednesday on MAPIA. So this was recorded before the new rules and then also before the election, but the basics of MAPIA and the comparative analysis are all there and they have not changed.
Great. Thanks, Sarah. Yeah, this is definitely a topic that I think you'll be hearing from us in the future. So definitely keep your ears open from that. And now we're going to move on to some kind of late breaking news with some still pending ACA reporting changes. And David's going to walk us through that.
Yes, thank you. So there have been two significant bills that are impacting ACA reporting requirements. These have recently passed in both houses of Congress and are awaiting signature by the president. They are the Employer Reporting Improvement Act and the Paperwork Burden Reduction Act. These bills were aimed at improving the reporting process for employers subject to ACA reporting on Forms 1095B and 1095C. Both bills would be effective as of January 1st, 2025, and include significant changes to the ACA reporting process. These changes include allowing forms to be made available upon request instead of required distribution, allowing employers to provide Forms 1095B and C electronically, and they also would extend the employer response time to letter 226J from 30 days to 90 days, and finally would establish a 6-year statute of limitations for collecting assessments. Until these bills are signed, however, employers must maintain the status quo. If they are signed and implemented, employers will definitely want to work with their ACA reporting vendor for any possible process changes.
All right, thank you, David. Yeah, I think this is a welcome change for any employers on the call today who have to deal with those 1095 forms. So we'll wait and see for the signature and kind of what that does. And now we're going to move on to some court case updates, and Patrick is going to lead us through some relevant court cases that we've seen in 2024.
Thank you, Kelly. We had a number of cases that came out this year that had some impact on the benefits compliance space, and I wanted to touch on a few of the bigger ones today. The first one I want to touch on is the Texas Medical Association versus HHS. I'm not going to get too much in the weeds on this case because it's actually a series of cases that have been bouncing between a Texas District Court and the Fifth Circuit Court of Appeals for nearly a year now. Suffice to say that it involves rules that implement the independent dispute resolution process created by the Federal No Surprises Act. It is as exciting as it sounds, so I'm not going to get into the details too closely. The important thing to note here is that in their deliberations, the Fifth Circuit has cited a recent Supreme Court case, the Loper-Bright Enterprises versus Raimundo case. And in that case, the Supreme Court overturned the Chevron doctrine, a piece of court. It's a court tool that the court has been using since the 80s, in which the courts are supposed to give deference to administrative agencies when it comes to rules that those agencies produce that cover subject matter that is within the agency's jurisdiction. In short, the courts defer to these agencies because the agencies presumably know more about the subject matter than the courts do. However, after Loper-Bright, the Supreme Court said that that is no longer the case. Courts don't need to worry about that anymore. So if the courts feel the agencies did something incorrectly, then they have more latitude to overturn or basically just kill the rule that's produced by the administrative agency. And in this particular case, the Fifth Circuit had used Loper-Bright as a basis for overturning some aspects of those rules in the independent dispute resolution process and send them back to the district court for further refinement. Another case I wanted to touch on that underscores this Loper-Bright impact is Tennessee versus Becerra. Tennessee is actually one of 15 states that challenged the Health and Human Services rule that prohibited health programs and activities that receive federal financial assistance from discriminating on the basis of gender identity. This is a fairly recent development in the rules. Before that, it was discrimination on the basis of gender. But just recently, the Biden administration has expanded that to include discrimination on the basis of gender identity. This is a district court in Mississippi, and the district court applied Loper-Bright as a basis for determining that the agency, in fact, exceeded its authority by inappropriately conflating the ideas, concepts of both gender and gender identity, and as a result has imposed a nationwide injunction on that expansion of the rules to include that discrimination on the basis of gender identity. Now, this is at the district court, so there are doubtless going to be appeals all over the place, and so we figure that's not over, but this is definitely an illustration of the impact that Loper-Bright case will have on administrative actions going forward, which in turn will have a pretty significant impact on the benefits compliance space. The other case I wanted to talk about on this slide is McKee Foods versus BFP. And this is a case concerning a pharmacy, an independent pharmacy in Tennessee that wanted to become part of a network in a self-insure plan in that state. And that state has any willing pharmacy law, which says that doesn't matter if you are part of another network or something, if you're a pharmacy that is willing to be incorporated into a network to provide services to network participants, then that should be allowed. Unfortunately, in this particular case, there is a PBM or a pharmacy benefit manager that worked with the self-insured plan to deny this pharmacy the ability to join the network. The idea here is that the federal law, ERISA, preempts state insurance law when it comes to self-insured plans. So, because it's a federal law that preempts state law. But in this particular case, the issue is whether or not this law that really deals specifically with pharmacies and pharmacy benefit managers, whether that creates an in run around the ERISA preemption. Again, this is ongoing litigation, but as many people have noted over the last year, there have been a lot of state action concerning regulating PBMs, particularly in which there might be a way to go around ERISA preemption and allow those state laws and regulations to have effect on even self-insured plans. So next slide, please. The next slide that we're talking about is the Braidwood Management versus Becerra case. In this particular case, the plaintiffs sued the federal government, asserting that the ACA's requirement for private insurance plans to cover preventative care that was unconstitutional. And essentially, what they argued was that the committees that are assigned the task of determining what care is actually preventative care and therefore must be covered were created and appointed in a process that is not itself constitutional. The North Texas Federal District Court agreed with the plaintiffs and issued a nationwide injunction against the preventive care mandate, basically saying that those preventive care practices are no longer need to be covered under the ACA. However, the government appealed to the Fifth Circuit, which temporarily stayed that nationwide injunction pending the resolution of the appeal. And in June of this year, the Fifth Circuit went ahead and officially reversed that injunction. But it did remand the case back to the district court for further proceedings, citing some additional administrative practices issues with the appointment process that undergirds the preventive care mandate in the ACA. So once again, this is not concluded, and so we don't know exactly what the ultimate fate of the preventive care mandate is. But at the moment, it is still the law of the land, and that preventive care must be covered by insurance plans in accordance with the ACA. So at the moment, it creates some uncertainty as to whether or not that part of the ACA will remain in effect next year. Next slide, please. And finally, I wish to talk about the Lewandowski versus Johnson & Johnson case. This is the first time you're going to hear about this case in this presentation, but it will not be the last, because it deals with ERISA fiduciary duties. The plaintiffs in this case are participants in a company health plan. They sued the company, asserting that the company failed to meet its ERISA fiduciary duties as the plan sponsor in its selection of a PBM, and failed to negotiate more favorable pricing terms for the plan and for participants in their PBM services agreement. So because they did not exercise their fiduciary duty, participants are required to pay more for drugs than they would otherwise have paid. At least that's the argument. Because ERISA imposes a fiduciary duty of prudence on plan sponsors, requiring them to act with the same care, skill, prudence, and diligence as a comparably knowledgeable plan fiduciary acting under similar circumstances. So this duty includes an obligation to monitor plan service providers and the like, including PBMs. And the plaintiffs allege that the company failed to meet this obligation. There's a pending motion to dismiss the case filed by Johnson & Johnson. So at this point, it's really impossible to ascertain how prescription drug plans and employer fiduciary duties might be affected by this case. But it seems to me that, or it seems to a lot of us, that other lawsuits will likely follow, also asserting that fiduciary obligations require plans to take a closer look at PBMs in particular, and perhaps other aspects of plan administration, so that plan participants pay lower prices. So employers, as ERISA plan sponsors, should carefully consider their fiduciary obligations. And we will be keeping an eye on this case as well as others that might be coming along. And if you are interested in seeing more of those cases, these cases, as well as cases I've already discussed, can be found in articles in our Compliance Corner newsletter.
All right, thank you, Patrick. Yeah, and that's a really good segue into what Carol's going to be talking about with transparency rules and then again, fiduciary obligations.
Yes, thank you, Patrick. The ERISA fiduciary obligations of group health plan sponsors really came to the forefront in 2024 Obviously, fiduciaries have always had these obligations, but most of the focus was really on retirement plans. They received all the attention. So I think this is a really positive development. Well, why did this happen? Patrick just touched upon some of the factors. The transparency laws were enacted, and these were designed to make healthcare pricing information and service provider compensation more readily available to plan fiduciaries. There was a concern at the time that fiduciaries didn't have sufficient information to fulfill their obligations to prudently monitor plan assets, their service providers, to act in the best interest of participants. So the transparency and coverage rule was first enacted. We know this requires public disclosure of plan pricing, in-network rates, and out-of-network allowed amounts, and soon it'll be prescription drugs too. And then there were numerous provisions under the Consolidated Appropriations Act of 2021, removal of gag clauses from contracts, so sponsors could have access to network rates and also claims information if they wanted to do an analysis, RxDC reporting to CMS, and of course the service provider, also known as the 408B2 disclosures. So these laws were enacted and they've been implemented, as we all know, over the past few years. And to some extent, the goals have been achieved because data analytic folks have been able to utilize the information in those machine readable files that we certainly aren't able to use without some type of expertise. And also there was a hospital transparency rule, and data analytics tools are becoming available and accessible to most health plan sponsors, so they can compare plan costs, and we expect those tools to keep getting better and better. And thus, the idea was to create a more competitive marketplace by comparison shopping both plans and participants, that this would essentially lower prices in the long run. All of that sounds great. Of course, the flip side of it is that once there's public disclosure of the information, then not just the plan sponsor can access it. And of course, we've seen, as Patrick mentioned, litigation. We have class action law firms filing suits against plan fiduciaries, alleging that they failed to use the information available to them, essentially, to properly administer their plan. He mentioned the Johnson & Johnson case involving mismanagement of a prescription drug plan, alleged. The Wells Fargo case was very similar, the claims against plan fiduciaries, but they also added one that the fiduciaries engaged in a prohibited transaction by causing the plan to pay excessive administrative fees to its PBM. This is tied to the obligation that fiduciaries have to make sure that their service providers are providing necessary service to the plan and paid only reasonable compensation. So these lawsuits, as Patrick mentioned, we really don't know what the result is going to be. We've seen a similar series of lawsuits in the retirement plan space beginning over a dozen years ago when they had similar disclosure obligations enacted. I think those cases are probably stronger. I think a big challenge here is for the plaintiffs to be able to demonstrate that they have indeed suffered an injury due to the fiduciary's actions, when typically in your group health plan sponsor context, the risk of loss is primarily on the plan and not the participant. So we'll have to monitor where these cases go. I think the third factor was regulatory attention, an increased amount of regulatory attention by the DOL. Sarah mentions the mental health parity enforcement efforts. We know they have been a priority, but the DOL is also looking at now claims review and adjudication. We expect that to be a focus in 2025. And they're also making sure that when they issue guidance and guides, they're pointing out, hey, that cybersecurity guidance we just updated, it applies to you also, health and welfare plan sponsors. This it just is not intended for retirement plan sponsors alone. Next slide. So what will happen next? We do expect more transparency laws, particularly related to PBMs. and unfortunately more lawsuits. So we'll monitor these developments. It's unclear how the change in administration will affect the regulatory focus or staffing in the employee benefits area. So we'll have to monitor that as well. So the question then essentially becomes, what should a plan sponsor do now faced with all this uncertainty? Well, it's certainly a great time to review their fiduciary obligations and governance practices. And because having sound governance practices is probably the best protection from potential liability. We know that the plan sponsor or their designee is typically the plan administrator and primary plan fiduciary and held to high conduct standards. They have to act solely in participants' interest, follow the plan documents, pay only reasonable plan expenses, and most importantly, for purpose of our immediate discussion, carry out their duties prudently. And this obligation focuses really on having a prudent process when you're decision making and not the results. So a court or a reviewing body is going to always ask, do that fiduciary exercise due care and diligence, that of a prudent expert in their decision making and their plan administration. And it's a failure to have that process in place and documented that can result in liability and unfortunately even personal liability to fiduciaries. Next slide. So what are some important elements of prudent governance practices? Certainly it's good to look at the governance structure. In many cases, for retirement plans, there's a committee and a formal structure in place. We don't see that as often on the health and welfare side. Sometimes it's just one HR person charged with a tremendous amount of responsibility. So the idea of establishing a formal committee by charter and comprised of individuals with expertise in various areas is certainly something to consider. As Patrick mentioned, it's not one size fits all, but certainly something to consider. And then the committee would schedule meetings at regular intervals to stay on top of compliance issues. Importantly, they should be maintaining formal minutes of the meetings and the decision-making process. Because if a claim of litigation ever arises, it could be sometime down the road. The legal process moves slowly. So you want to make sure that you have a record that you engaged in that prudent process. In your decision-making, thorough research and deliberations. Importantly, too, always consult with an expert if you're unfamiliar with a topic or if a conflict of interest exists. Maybe you're a self-funded plan that reviews claim appeals. Maybe you're looking to hire a PBM. You're going out to RFP, and part of that is reviewing the contract terms, and you really don't understand them. Well, then you need to hire an expert that does. Important also that you periodically evaluate and monitor your decisions. So you select that service provider, but are you monitoring them? And sometimes that involves making sure, for example, you have audit rights in contracts. You have the ability to monitor what that service provider is doing. And I think an important element of any governance practice is a desire to continually improve, because we live in a very dynamic employee benefits world. And we don't know what we're going to be facing in 2025. And I expect there'll be even more of a focus on fiduciary obligations. So you just want to keep improving those practices. More to come. We'll be focusing on this topic in 2025, and I hope you join us.
All right, thanks, Carol. Sorry, I just went the wrong way. All right, there we go. All right, thank you, Carol. Yeah, and so now we are going to get, Yoko is going to talk about some of the state law trends that we've been seeing recently.
Great, thank you. So for this section, I'm going to talk about the PFML, also that includes disability insurance and paid family leave, and I'll hit the upcoming to-do list for overall state requirements. So first off, as you see on the map, so the yellow stars that you see are the paid family and medical leave. That includes the disability insurance and paid family leave that are enacted, and either it's in the operation or as of January 1st, 2025, the program will start then. And only the two that are in the future dates are in Minnesota and Maryland. So this is a good map to see, like, to review your employees where they primarily work and make a note of the which state PFML will you need to subject to. And then even if you have, except for the Delaware, even if you have only one employee working in that state, including like working from home, you are required to comply with several requirements by the state, like register with the state portal, collect a payroll, and then do the reporting quarterly, and all sort of things. But we have all the resources to support you and navigate you through. But it's very important to just review your employees' work location and understand which state PFML you are subject to. And this applies to, importantly, majority of the state laws tend to apply only for the fully insured plans, but PFML, when it comes to it, it applies to both fully insured and self-insured employers. And except for Delaware, it applies even if you have only one employee working from home, for example, in Oregon or somewhere in one state that are away from your work location. And one things to note is that that usually applicability of PFML generally align with your state employment insurance state tax for that employee. Thank you. And as mentioned, the upcoming ones that are captured in the green box you see there. So in a few weeks, as of January 1st, Delaware and Maine, if you're subject to it, if you have any employees working in those states, you're required to start collecting the employee portion of premium as of January 1, 2025. And the employees will be able to take the benefits, qualified reasons, for example, employees on disability, would take time to bond with their newborn or adopted child, or to care for family member. And so benefits will take place later after the payroll deduction, except for the Minnesota. So it's important to really double check. And if you find out that you're actually subject to it but haven't taken any actions, this is a time for you to communicate with a payroll vendor to make sure that your employees in Delaware and Maine are registered and set it up properly. So as a one-on-one, they can start withholding the employee premium. And there are a couple of states that require annual notice requirements. So it's important for you to review which states require new notice requirements, poster distribution. And importantly, to update your leave policy as well. And for the action plans, sorry for my voice. For the action plans, it's important for overall, not just for the PFML, but review your own existing employer leave benefits. For example, some employers provide like parental leave or time off to care for family member, seriously ill family members. So it's important to overall see how that would coordinate with each state's employee benefit duration, how long they can take time off or weekly benefits. And then you make sure that leave policy indicate that wrong with the federal PFML. Next slide, please. And the upcoming requirements, one of them is that as the ACA removed the penalty for the individual mandate, some states that listed there on the page enacted their own state version of individual mandate. And in order to enforce that, those states require plan sponsors or the carriers to submit a copy either of, generally speaking, 1095-C to the state so that they can enforce individual mandate at the state level. So that mandate penalty will apply on the residence basis. So it applies, the reporting requirement apply to your employees on the resident state. So it's, and then generally speaking, fully insured employers, you should double check with the carriers. The carriers are doing the reporting on behalf of you as an employer. And self-insured employer, generally speaking, they are responsible to submit the copy of 1095-C to the state on a timely basis. And the deadlines are generally fall within the first quarter. And the first deadline is coming up at the end of January for Massachusetts. And they use, that's the only, not the only, but that's the state that use their own form, 1099 HC. And that's the one that you need to kind of evaluate whether your coverage is meets their MCC requirement, kind of like an MEC requirement. And then we have the publication. Did you see if you have any additional information? And we're here to support if you have any questions. Next slide, please. And other upcoming requirements within the next couple months. The first one is deadlines actually, yes, a couple days ago, but hopefully you're done with the Massachusetts HERD health insurance responsibility disclosure requirement. This is an online disclosure that employers with 6 employees in Massachusetts are required to do the online reporting requirement on the annual basis on their specific portal. And other requirement is the Illinois Consumer Coverage Disclosure Act. And this applies also for the fully insured and self-insured, according to the state statement. And the timing of distribution is when you hire an employee in Illinois or on the annual basis. And this was enacted a few years ago. So this might be a 3rd year that you'll be doing this. And 2025 template is available. The link is included there. And that template is basically indicate the state EHB, and you indicate your own plan. And DC, switching the gear to the DC. For the DC employer, if you have any employees who have at least 20 employees, including part-time, full-time, working DC district, then you're subject to this DC parking cash out law reporting. This reporting is due every other year. So this is the 2nd year that employer, if you're covered employers, need to do the reporting online. And then the purpose of that law is to reduce employee from commuting by car, but encouraging the employees to commute by public transportation. So even if you don't sponsor a public parking subsidy, you still have to do the reporting. And deadline is on January 15th, 2025. And last one is the San Francisco Healthcare Security Ordinance. And this is not a new law, so you may be already familiar with this, but this is subject to, this will apply to you if you have at least 1 employee working in that city of San Francisco, that the boundary, and then overall count, including a worldwide count, is at least 20 plus employees for private employees. And for your requirement is that 2025 poster is now available. So you're required to post that in your workplace. We'll provide it electronically by email to those remote employers. And as you are already aware, the annual reporting is due every year at the end of by the end of April. Okay, next slide, please. And the commuter transit benefit, for the interest of time, I'm not going to detail, but here's a list of city and state that requires employers, specific employers, to offer commuter benefit options. Okay, hand it back to you, Kelly.
All right, thanks, Yoko. Yeah, definitely some good content there. And now we're going to move over to Sharon. I think this is a topic probably a lot of people are interested in, to kind of understand what's going to happen at the end of this year, and then how the elections may impact benefits in 2025 and beyond.
Thank you, Kelly. So we've just been talking a lot about facts, and now let's take a minute and talk a little bit about speculation, right? So we'll talk a little bit about the regulatory and legislative landscape. So typically, when we have a change in the White House, we will see a flurry of regulations and other guidance from the current administration to try to complete their regulatory agenda. And we are expecting the same to be, happening here, especially as we're rapidly approaching the end to the Biden administration. So it is our understanding that there is some rules sitting at the White House beefing up the No Surprises Act, and they're in their final stages of review. So these rules would finalize what Patrick had talked about, which is currently being litigated, this independent dispute resolution process for surprised medical bills. And very generally, the IDR process is designed to resolve payment disputes between health plans and out-of-network providers. And there's a certain process that is followed when they can't agree. And then ultimately, there's a resolution that comes through the process and it is binding. So it makes things in terms of employer plans, more predictable with billing and prices, and it can lead to cost and administrative efficiencies. There's also some proposed regs on health data sharing and cybersecurity updates to HIPAA. Those rules have not been updated in about 20 years. And they're currently at the White House. And these proposed regs would just be aimed at improving data and information sharing and making things more secure between all the healthcare stakeholders like employer plans and insurers, TPAs, and PBMs. And sometimes these, like when we got the first HIPAA security rules, they require a little investment in infrastructure for employer group health plans and then the business associates of these employer group health plans, but then they ultimately lead to efficiencies and lower costs. And I think we all can agree that when PHI is more secure, we have fewer breaches and fewer lawsuits. Lastly, it's possible that CMS is going to release their latest round of Medicare drug price negotiations before January 20th. That doesn't really impact employer plans, but I think it's something that the Biden administration would like to take some credit for. And the theory is that those prices will eventually trickle down to the private sector. In terms of the legislative session, as David mentioned, we got President Biden has two laws sitting on his desk, the Employer Reporting Improvement Act and the Paperwork Burden Reduction Act, and both of these are related to ACA reporting, and they're both very good for employers. They help relieve some of their burden. Congress is also required to pass a budget or a temporary funding extension, which is called a continuing resolution, before they go on break, which is December 20th. That's Friday. And they have to do that to avoid a government shutdown. And nobody wants a government shutdown over the holidays. It is very messy. Last night, they finally released the text of a CR that they have, on the table that would fund the government through March 14th. This is a continuing resolution, not a brand new budget. And then in March, they will have to start the process over, except we'll have a different Congress and a new president. And the continuing resolution does include a 2-year extension to telehealth, which would extend this first dollar coverage of telehealth services for HDHP and HSA participants. And the bill also includes some reforms. I know we've been mentioning throughout this presentation PBMs and sort of some of the litigation that is involving these PBMs. And so this continuing resolution is putting some requirements on them that they disclose their rebates and discounts that they have and that they provide more transparency through their compensation that is contracted for, and that they pass through these rebates and discounts to the group health plans. So we will see eventually how that takes hold. There was some thought that the CR might include some guidance on HDHP, HSA users, and preventive care for chronic diseases. We have guidance that was issued in 2019, and the Biden administration followed up on that guidance, allowing first dollar coverage under an HSA for preventive care for certain chronic conditions like diabetes and asthma and heart disease. And I have looked in the bill, I cannot find it there, but this is a bipartisan issue and it does come from 2019 IRS guidance. They're looking to codify it in the law so that it's more permanent. And so it's not clear to me that President Trump might not repropose or put this bill back up there. We still have 2 days, so we'll see what happens. There There is some concern, I think, with the Biden administration on these enhanced premium tax credits, which are set to expire at the end of 2025. He would like to have those extended now. I'm not sure that that's going to happen. And then President Biden is probably trying to get all of his judicial and administrative appointments pushed through to the best that he can before the year end. So next slide, Kelly. So what do we expect in 2025? I mentioned here that we need to expect a fluid year. And what I mean is that we're probably going to see a lot of different adjustments, you know, kind of this 2-step forward and 1 step back. And employers have to remain flexible. I think the Trump administration, I know that Sarah and my colleagues have been mentioning, are really going to take a close look at all the guidance that has been issued. And there are several vehicles for them to do that, and for Congress to do that. So they can use this Congressional Review Act, they can use the Administrative Procedures Act to basically pull back regulations that have not taken effect yet, or to repropose regulations that are final, to tweak some of the things. We think, for example, that these proposed rules dealing with coverage of preventive care for contraceptive coverage or over-the-counter coverage for preventive care, they might pull them back and tweak them. There was a court case yesterday that came out about short-term limited duration insurance and fixed indemnity. There's a requirement there for how many months and years that coverage can be offered, and there's also a notice requirement. That guidance came initially through President Trump, but the notice requirement came under the Biden administration, and a trial court in Texas found that that was unlawful, that they could not require that notice. And so we are going to see if the Trump administration is going to continue that litigation, appeal it, and we'll have to see what happens. But there's a little bit of a little back and forth, and we'll see what's going to happen. It's possible that, this new administration is going to do the opposite of what we've just been through. So they're going to try to expand these non-traditional plans. They're going to limit reproductive and gender affirming procedures. And then maybe they're going to take a look at that comparative analysis and the burdens that it imposes on insurers and make some adjustments there. Last slide, Kelly. All right, so if we just take a quick look at what we've got in Congress, we have a slight majority in the House and the Senate. The House promotes these taxation and revenue bills. All they need is majority to push them through. The Senate can use a majority to push through any sort of budget reconciliation, so anything that has to do with the budget. And it's possible that we're going to see, again, more expansions of HSAs and pricing and transparency and things like that. I will say that President Trump has promised a tax break, and those things cost money. And so I do think we will see a tax break, but then will he be looking for some pay-fors, which might be the employer exclusion for health and welfare benefits. But we have been through this many, many years in the past, and we've been through it more recently with the Cadillac tax, and it eventually gets thrown out. But we will see in the weeks to come what's in store for us. And Kelly, I'm going to turn it back to you and Molly to take us through the end.
Yes, thank you, Sharon. Yeah, definitely. I think 2025 will be an interesting year with some of this. And so more to come. So make sure you're watching out for our compliance corner and other resources that we have. And Molly's going to take us through some general year-end reminders related to benefit plans.
Yeah, thank you. So whether you're Santa or in HR, 'tis the season for checking off to-do lists. And I want to spend our last couple of minutes here going through a few items that you just need to make sure are taken care of before the end of the year. So first, we have the gag clause attestation. For the second time ever, medical plans need to be telling the government whether or not they're, or specifically telling the government that they do not have any clauses in their contracts that restrict what kind of information can be made available. it's going to be important that you confirm with your carrier or your TPA whether or not they will complete this on the plan's behalf, whether you're fully insured or self-insured. It does need to be done, but hopefully the service provider is doing it for you. If they're not, then it does need to be submitted online. There is a web form on CMS's website where you can do this. This needs to be completed annually, no later than December 31st. Next, we have some new HIPAA reproductive healthcare privacy protections. So basically, this relates to any sort of request that a covered entity or a business associate, which means basically a group health plan or service vendors such as NFP or your TPA, might receive regarding maybe an investigation or law enforcement with respect to reproductive health care. So all group health plans are subject to this, all covered entities and business associates, but self-insured group health plans in particular need to be reviewing their written policies and procedures to make sure that reproductive health care in particular is going to be protected in the ways required by this law. Also, if you do receive a request, which would probably go through the carrier or TPA level, but if your plan does receive a request for reproductive health care related information, then you need to seek a new attestation from the requester. And there is a model available. Now, as Sharon just went over, this is one of the items that will probably be under review or even on the chopping block altogether with the new administration. So stay tuned, TBD. Next slide. Finally, we have some kind of very routine tax reporting obligations that you need to be aware of ahead of finalizing those W-2s for employees. First of all, make sure that you have included all of the imputed income that is required for group term life insurance, particularly that group term life insurance values over 50K. As well as domestic partner benefits that your employees might be receiving. Second, you need to make sure that you are reporting on the total value of healthcare coverage per the ACA on employees' W-2s. These are not new items. They've been around for a long time. Hopefully your payroll provider is already doing them. However, this is the time to go ahead and review that, make sure it is being reported, and make sure that your employees' W-2s are accurate before they're being distributed. Okay. Finally, I want to round you out with a discussion of what's going on with telehealth coverage with regards to HSAs and high deductible health plans. So historically, telehealth has been considered first dollar coverage. That means that you are able to use those benefits without first having to satisfy the deductible in a high deductible health plan. And what that meant was you would not be eligible to contribute to your HSA if you did use those benefits. Now, back in 2020, the CARES Act, which was the COVID stimulus bill, included a little rule that basically disregarded that. It said, you know what, because everyone's at home, working from home on their computer all the time, we want to limit who's going out and about in the world. We'll go ahead and say that you can use telehealth benefits without it disrupting your HSA eligibility. That was extended a couple of times, but as things stand now, it's going to expire at the end of this year, December 31st, 2024, which means that if nothing comes out in this appropriations bill or this continuing resolution that happens in the next couple of weeks, as Sharon mentioned, if nothing is included to extend this telehealth relief, then what that means is as of January 1st, 2025, any telehealth care or coverage that your employees receive is going to jeopardize their ability to contribute to an HSA. So employers will have to make some decisions about how they want to handle that. For example, do you want to go ahead and calculate the fair market value of that telehealth coverage so that employees do have to pay something? Do you want to go ahead and make that post-deductible only? Or do you want to just, include a lot of very stringent warnings to your employees about how they might be affecting their own HSA eligibility? So stay tuned for that. We will be sure to let you know whether or not telehealth coverage remains HSA compatible after the new year.
All right. Thank you, Molly. And yeah, thank you everyone for sticking with us. I know we covered a lot, but hopefully you found it helpful. Again, you'll get a copy of the slides And if there are any of the publications we mentioned, please request those from your NFP consultant or account team, and they'll get you taken care of. And with that, I will hand it back to Amber to close us out.
All right, thank you. And thank you to all of our speakers for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you'll receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you everyone for joining us, and have a great day.